With Matthew Brinckerhoff, this morning's hearing was very brief. What exactly happened?
Basically, the Empire State Development Corp made a request or an application to make another motion. Notwithstanding their allegations that we're constantly delaying, they want more time and they want to submit more arguments. And the argument that they want to make, as I understand it and will make now, is that we're in the wrong courthouse, which sounds somewhat familiar since we've heard that many times, and that everything should be transferred to Kings County to Justice Gurgis. And as I understand the argument's going to be, now that transfer of title has allegedly occurred, the proceeding implicates real property in Kings County, and therefore venue is appropriate in Kings County, I think will be the argument. And they also want to argue that we are precluded or stopped, foreclosed from bringing the case at all because, according to them, we lost the exact same case already in front of Justice Gurgis, and it's final, and that precludes us from bringing the same case again. Obviously, the problem with that is it's not the same case, it's not final, the parties are not the same. All of the things that you look at to determine whether that kind of doctrine applies don't exist here. Well, they'll make their argument.
There's one additional party, is that the deal?
There's one additional part, yeah. There are many, many reasons why this doesn't work. One is that there's one party which wasn't subject to the Article 4 proceeding, and that's the Gellin group.
They're in the second phase of
correct, and they are a petitioner in this case.
Right.
So that actually does serious damage to their venue motion. It certainly wipes out any res judicata or collateral estoppel arguments that they might have, and that's just the tip of the iceberg, though, because in order to be final, you have to have litigated the same issue under the same circumstances to conclusion. And we filed a notice of appeal of the Justice Gurgis' decision in the Second Department. There's no final order. And so it's no more appropriate now than it was a month ago when they could have made the same motion, but they didn't. And they didn't because they knew they couldn't.
So you filed a notice of appeal. Does that mean you're actually going to appeal, or does it mean you're preserving your right to do so?
It means that we intend to appeal, because when you file a notice of appeal, there's no point in doing it unless you intend to. We have not perfected it yet, which is when you file your brief and your record and everything else. I don't know when exactly we're going to do that, because now we're going to be busy with this.
When we talked last week, you said that, I asked, what's the difference between this case and the case before Gurgis? The same arguments are there. What makes this different?
Well, I mean, the biggest difference is the procedural difference, right? We were raising defenses and a motion in defense to an Article 4 proceeding that all of the cases say is extremely limited, right? Only to procedural errors.
Article 4 is condemnation?
Correct.
Okay.
Sorry. Article 4 of the EDPL. We were trying to block the actual filing of the acquisition maps, which if filed correctly, might transfer title. And it was in that specific context that we made these arguments. And so, because the context is different, it's not the same. But even more than that, if you look at Justice Gurgis' opinion, his fundamental ruling was that our arguments to that effect, our arguments that he should consider everything that's occurred since December of 2006, he said that those arguments were untimely. He dismissed them essentially on statute of limitations grounds. And he even acknowledged, if you had filed this case, meaning our defense to the Article 4 proceeding, by January 19th, it would have been timely. Well, guess what? This case was filed on January 19th. It's unquestionably timely. Nobody's saying it's not timely. So insofar as he's saying we weren't timely there, we're certainly timely here.
And so one of the things you wanted to do in that case, and you're trying in this case, is to get the development agreement into the record so the judge can evaluate it. So that's still pending, correct?
That's still pending. And I've made a specific motion that I mentioned today to put the development agreement into the record, to have detailed allegations about it in the petition that will be similar to, but presumably more detailed than the motion to renew and re-argue that was filed in the other case before Justice Friedman last week.
And the approximate timetable on this is to send in the motions, to file the motions?
Yeah, we worked out the schedule with the clerk. All motions are going to be heard on May 12th at 11 a.m. They have to file their motion by this Friday, they're going to file it a particular way by this Friday. It will be served by Monday. My papers are due on May 3rd. Their reply papers are due on May 7th. And the court will hear on May 12th. So it's all set.